Court does call the case. People versus Sonia McLean. You got it? We clear in? Yeah, okay. All right.
Oh, hi. Sorry, are you working?
Yes. All discovery is complete.
That's the mission. Where we go?
This is B3.
There's no need to approach, well, Mr. Brown has to approach you kind of, but, Mr. Brown has asked me, a couple times for any videos in this case. I've sent, multiple emails to YPD requesting any audio or video. They've probably unresponded to. So there may or may, I don't know if there is any video or not, but my request for any video has gone unanswered. I have no issue with setting it for a PE. If something turns up, we'll cross that bridge and we get there.
You can dismiss it.
Well, I realize is there a reason to believe that there is video?
Yeah.
Okay, and the people have, you requested, Mr. Brown, people have requested a YPD, and they just have not.
They're ignoring. I'm used to that, but.
I guess, Mr. Childers, to the extent that they're not, there's no response. Is that?
The response is not that there is no video, there's just no response.
Then if
I suppose if the court wishes, I could elevate my email to see if I email command staff, if they may respond, but no. It's certainly worth a shot. If we want, in an effort to keep the case moving along, I can stand towards the end of September, and I can continue my efforts.
well, I don't know why it's one thing if there's an issue getting discovery. This is a whole other realm.
Yeah.
Where they're not responding to a legitimate discovery request. And, you know, and I'm not trying to disparage any department, but the last time I ran into this was with YPD. And I ultimately ended up dismissing the case. All right, here's what we'll do. She wants to say something with her law degree.
Yeah.
I don't think she does. The people around you are doing just fine. Okay? So here's what I'm going to do. I'm going to set so as not to impact the defendant's rights. I'm going to set the preliminary examination. Mr. Brown, prepare an order for my signature that directs that YPD is to turn over all video. I will set this examination for the 17th. It is the 4th. So I'm going to need it right away so that there's time. But that they're to turn over all video to the Washington County Prosecutor's Office by the 11th. And if they then, that will go under my signature. That way, if they then fail to do what I'm ordering them to do, then the court will take appropriate remedies.
Your Honor, from a logistical standpoint, once that order is signed, would you like for me to send that order along to YPD?
Yes, please. Preliminary examination in this matter. will indicate discovery is not complete, but preliminary examination in this matter will be set in person September 17th, 2024, 9 a.m. That will be before me. And then bond will continue. Now, given all of that, ma'am, is there something you wanted to say?
She was trying to leave and go to the, get on the bus, and there was some contact, so we had to contact Pittsfield Police to make a narrative report that she was not in violation of any court orders. I have a copy of it if you'd like.
Hold on.
Just like to be able to get on the bus.
Hold on. You gotta catch me up because that was today.
No, that was the last time.
22nd,
22nd.
Mr. Morgan,
Just hold on. Okay, you're good. So, well, I just want to make sure I'm clear. You got on the bus. You were, okay, but in any event, you ended up on the bus, right? All right.
Because Ms.
Hey,
Morgan,
but hold it, just hold it, just hold on a moment, okay? And then at some point, the alleged victim in this case came into contact with her.
Yes.
As I'm to understand, based upon what you said, Mr. Brown, she then contacts the police.
She comes back here and asks for my advice. So
Got it. That's it. I don't want to know what you two discussed. But out of that, there then is generated a report from Pittsfield.
yes,
Got it. And so your concern, ma'am, is that somehow the court may try to hold you responsible for that contact. Okay. I have not seen the report. I do not think that I need to see it. Okay. I'm going to make a presumption as to the advice that Mr. Brown gave you. I think that was absolutely appropriate advice. And should the issue arise, then I would review that report and I would take that all into consideration. All right. But at this point, I am not going to do anything. I don't have a complaint that you've done anything. And so I'm not going to make one. Fair enough?
I need time to get on the bus again. Leave out the courtroom and then get.
Okay. All right. Listen, just listen. Mr. Brown gave you advice, okay, regarding a situation that you had, I guess, last time that you were here, right? So it would seem to me, would it not, that should you leave and that same or similar type of thing happen, that you would then follow the advice that your attorney gave you? And I kind of indicated to you at this point how I'm looking at it. Okay? I know it may worry you, but I think follow what your attorney is telling you. All right? Okay, anything else you want to yell at me about?
I just want to have time to leave.
Not what?
I don't want to have the same issue that happened last time I was here, Your Honor. And you asked Ms. Morgan to stay away from work. No.
Okay, hold it. Where is Miss Morgan here?
Yes, Your Honor.
Okay, you need to sit down.
Can I say something?
No. All right. So you need to get on the bus. Okay, stop for a moment. Ms. Morgan, do you need to get on the bus?
Yeah, the bus has video, didn't know that happened, I got on the bus.
Okay,
The bus has video, she's lying.
And I'm going to presume you both take the same bus.
I don't have a
Okay. I wish you would stop yelling up here at me. Mr. Feaster? I'm not going to ask you to drive anybody, so don't tell me. I'm just, so, okay, here's the thing I do not know. And I'm going to maybe potentially embarrass myself. I have not taken a bus.
Shame on you.
Well, no, I don't. Wow. But I just haven't. And so I know that when I get on a bus, or when I did, but it is so long, the dinosaur was pulling it. But anyway, it just took me downtown, and then I had to find another bus. And I just told myself I'm not doing all that. So that's why it's my limitation. How often do the buses come to where you would have to pick the bus up, get the bus?
Every 15 minutes across the street.
Every 15 minutes across the street. Okay, so here's what we're gonna do. Okay? This time around, you get the first 15 minutes. Remind me the next time, then you'll get the first 15 minutes, and then you gotta wait and take the next bus. Huh? Oh, so now you took up all my time, now you wanna leave? No, go, just go. That's what we're gonna do. You go, don't get up, Miss Morgan, do not get on that same bus. Do not get on that. That's fine. I don't want you both on that same bus.
Still approaching me and sending threats to me, Your Honor, and that is the process.
Then you report that to the prosecutor's office. They will raise.
I told him again.
Don't know how to change it, right? Okay, so I will just say this, Ms. Morgan, when it is raised before me in a proper way by the people, I will deal with it, much like said I would deal with her issue. But right now, I want you to take the next bus. The next time around, you'll get the first shot at the bus, she'll wait. Thank you.
This courtroom hearing begins like many others, quiet, procedural, and seemingly routine, but slowly unfolds into a revealing moment about fairness, authority, and how the justice system is supposed to protect individual rights, even in tense and confusing situations. The case of People versus Sonia Milan is called, and from the very beginning, the atmosphere signals that something is not right. The defense attorney explains that discovery is not complete despite multiple formal requests. Specifically, the defense has repeatedly asked for audio and video evidence, which could be crucial to understanding what actually happened in this case. However, those requests have gone unanswered. There has been no confirmation, no denial, just silence from the police department. In a courtroom, that silence is a serious problem. The judge immediately recognizes the gravity of the situation. Discovery is not optional. It is a legal obligation. When law enforcement fails to respond to valid requests, it doesn't just delay a case, it threatens the defendant's constitutional right to a fair trial. The judge makes it clear that this court will not allow the process to move forward while one side withholds information, intentionally or otherwise. To protect the defendant's rights and keep the case moving, the judge takes firm action. Formal court order is issued requiring the police department to turn over all video evidence by a strict deadline. The order is clear and enforceable. If the department fails to comply, the court will take appropriate action. This moment sends a strong message. The courtroom is not a place for excuses, delays, or selective cooperation. As the legal discussion continues, The focus shifts from paperwork to people, and the human impact of the case becomes clear. The defendant expresses concern about a previous incident after an earlier court appearance. She explains that she attempted to leave the courthouse by public bus, but unexpectedly came into contact with the alleged victim. Police were contacted, not because she committed a violation, but to create a narrative report documenting the encounter. Understandably, the defendant is anxious. She fears that this interaction, despite her intentions, could somehow be used against her later. The judge listens carefully and responds with clarity and reassurance. There is no complaint before the court. No violation has been alleged. Punishment is being considered. The judge openly states that they trust the advice given by the defense attorney and confirms that, unless the prosecution formally raises the issue, the court will not act on assumptions or speculation. This moment highlights something rare but important: a judge taking time to calm fear instead of escalating it, and the hearing takes an unexpected, almost humorous turn. The judge candidly admits unfamiliarity with the local bus system. It's a brief but humanizing moment, one that breaks the tension in the room. Yet, even during this light moment, the judge remains focused on preventing future conflict and ensuring clarity for everyone involved, to avoid any chance of another unwanted encounter. The judge sets a clear and practical boundary. The two individuals involved are not to take the same bus. One will leave first. The other will wait for the next bus. Simple, direct, enforceable. There is no yelling, no punishment, no unnecessary escalation. What makes this moment powerful is not drama but restraint. The judge continues the bond, schedules the preliminary examination, and ensures that all parties understand their responsibilities moving forward. The message is unmistakable. Fairness, communication, and compliance with court orders are non-negotiable. This hearing serves as a reminder that justice is not always loud. Sometimes it looks like a judge insisting on transparency. Sometimes it looks like protecting a defendant from being unfairly blamed. And sometimes it looks like preventing conflict before it even begins. In the end, this courtroom moment isn't about chaos or confrontation. It's about control, clarity, and the quiet enforcement of the rule of law. It shows how a court can maintain authority without intimidation. And if you want to see real courtroom moments with real consequences, like this video, comment your thoughts. Did the judge handle this the right way?